Right of procedural due process. No person shall be held to answer for a capital crime, unless on a presentment or indictment of a grand jury, nor shall any person be subject for the same offense to be twice put in jeopardy, nor shall be compelled to put a witness against himself, nor be deprived of life, liberty, or property without due process of law. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, and to be informed of the nature and cause of the accusations, to be confronted with the witness against him, to have process for obtaining witness, and to have the assistance of counsel for his defense. The right of trial by jury shall be preserved. Procedural due process can be viewed as a series of steps established by the 5th, 6th, and 7th Amendments that protect the rights of the accused at every step of the investigation and limit how governmental power may be exercised. The following steps represent the steps taken: the manner in which the evidence is gathered, 4th Amendment; the charges made by the police upon arrest, habeas corpus; the formal indictment and interrogation, allowance made for obtaining lawyers, witnesses; the trial, speedy and public trial, impartial jury, guarantees against self-incrimination, trial by jury; and the right to confront witnesses. Another kind of due process, substantive, places limits on the government as they relate to the content of legislation and the extent government can use its powers to enact unreasonable laws. Before looking at key cases, you should have a clear understanding of the intent of each of these steps. Habeas corpus, a right that cannot be taken away by government, found in the body of the Constitution in Article 1, Section 9, has also been called a writ of liberty. It directs the police to show cause why a person may be held for a crime. It has also been used by convicted criminals as a route to appeal their conviction from the state courts to the federal courts based on procedural issues. An indictment is a formal list of charges made by a grand jury. When enough evidence is given to the grand jury, it develops a list of formal charges that is presented to the accused prior to trial. A speedy trial has been defined by law on the federal level as a trial that must take place no more than 100 days after arrest. Each state has laws addressing this issue. A public trial means that it is held in a public courthouse. Depending upon the specific issue, the extent of public viewing and media coverage can be determined by the judge. The right to a jury trial does not necessarily mean that the jurors will be identified by name. In the trial of the World Trade Center bombers, the jury was chosen in this manner. In obtaining an adequate defense, the conditions in which a defendant can obtain a lawyer based on financial considerations and the exact time a lawyer is brought in are not defined. Double jeopardy means that once a verdict is handed down, you cannot be tried twice for the same crime. That does not mean that if you were found innocent of state charges, you cannot be tried for a federal offense dealing with the same issue. That is what happens to the police, and that is what happened when they were involved in the beating of Rodney King. Surveys taken have shown that much of the public is critical of the manner in which courts have interpreted these provisions. Crime and violence have become a national concern. Anti-crime legislation and Supreme Court decisions have responded to the public's concern. Some of the questions raised by these amendments follow. Can due process rights be suspended during times of national emergencies? Is live media coverage of trials allowable? Does a lawyer have to be assigned to a defendant who cannot afford one? At what point does the accused have the right to consult a lawyer? To what extent do the police have to advise the accused of their right?